Hey everybody, my name is Danny Dumas, and this is the Earn Your Title podcast. I have my friend Sean Parent. Sean, tell us what you do, and then I got some, I think, really important questions. So what do you do? How do you do it? Just give me a little oversight on what it is.
Sure. Well, first and foremost, thanks for the opportunity to be here. So, primarily what I do is estate planning and business planning legal services. So on the estate planning side, it is, drafting wills and trusts, helping families establish guardianship parameters, just basically protecting families from the unforeseen events that unfortunately befall all of us. And then on the business planning side, I do entity formation and kind of counseling as far as, what type of entity you might want based on what type of business you want to set up. I do contracts, operating agreements, things of that nature.
Awesome. So you said one word, and I'm going to focus on that, is that for protection. Mm-hmm. You use that word protection. And I know that as a husband and a father, especially as a father, I feel like it's like deep down in my DNA to protect my kids. Like that is, like I think my wife wants to provide for them, and that's just an innate. And I don't know if you're the same, but I feel like I want to protect them, but I know that I have a blind spot because I can like see like, bad people break into people's houses, and I have like motion sensor lights outside and a gun in the house for protection. I know realistically the odds of me needing to protect my family from a physical harm is like almost zero. Mm-hmm. Statistically, if you find the closest whole number, it's zero from where I live. But I do think about it because it's something you can see, it's out there in the world. But protecting your assets or protecting your kids and getting them in the right place is going to happen. Now, hopefully it's a long time for me. Like hopefully that is down the road. But I know that at some point me and my wife are going to die. And the legacy that I leave financially and all that, if I don't do something right, I know it's going to be hard, at least at best challenging if I don't do anything. And if at worst, non-existent for my family. So what can a guy, and maybe take us from like the easiest thing to do, you're a new dad with a bad job and you're broke and you're just married, to, I've got some things established. I've got a little more money. I can spend some money on protection. Maybe take us like through the continuum of what can I do without spending any money? And then maybe what would be the best possible thing I could do for my family? What would you suggest?
Sure. So, the one thing that anyone can do is have a will. And that is the one document that, if you have kids, you should have a will. Now, I'll talk a little bit more about why a will is not optimal for estate planning purposes, but the one thing that it does that no other document does is it allows you to name the guardian and conservator of your minor children in the event of your incapacity or death. And without that document, it's left up to the courts. Now, a lot of times that is going to come down to who's the loudest person in the room. The courts will, grant the petition, especially if it's uncontested, of any person who they, cannot find a reason to not appoint. But that is not necessarily going to meet with your wishes as far as who takes care of your children. And, that's kind of the example that I use is like, imagine you have the loud relative who you don't want to raise your children. And then you have the quiet, reserved aunt or, cousin or whatever that you would like to, who's not necessarily going to fight that fight. So by having a will in place, you can ensure that that wish is honored in court. The other thing about a will that's really nice, especially in Michigan, is that we honor what's called a holographic will. I'm always going to recommend that you use an attorney to create a will because there's a lot of things that, people aren't going to think about, that an attorneys are trained to think about when drafting these documents. But the nice thing about a holographic will is that all it has to be is written in your handwriting and signed and dated by you. So you can literally take a scrap piece of paper, say, this is my last will and testament. These are the things that I want. Sign, date it, let somebody know where it is, of course, and that's valid, and that's honored in court. So yeah, if you have no resources, no ability, that is definitely an option for you.
Random question. could that be like, say I save it on Google Drive and it's a digital copy, or does it need to be a piece of paper with my inked handwriting on it? Like, does that matter?
So that's a good question, and it is subject to change, but there was actually not too long ago a court decision in Michigan. It was a person had created a holographic will through the app Evernote, and that was actually found to be valid. The nice thing, and I think technology, just kind of the changing nature of the way that we do business is having an impact on that. But a lot of the laws, especially in Michigan, are starting to favor remote, online, notarization, because really the core of it is did you sign this? Did you intend for it to be a will? So yes, you can do it that way.
Okay, so today Andrea comes home, me and her sit down and say, we want, Brent and Emily Welch to have our kids and all the assets that go along with it signed. That is not the best, but it's a start and it's free.
It's a start and it's free. Yep.
Cool. All right. What's the next step? Maybe I've moved on a little bit. I have acquired some more assets. I can afford professional help like yourself. What would be the next thing we would want to do or think about to make sure that we're protecting our kids and make sure they have, that our plan is put in place as opposed to somebody else's?
Mm-hmm. So, the next step up would be just a will drafted by an attorney. That's going to be the least expensive way to kind of protect that. However, I only really recommend that if you do not have an attorney that'll work with you on a payment plan, or you do not have, and do not anticipate having the assets to do a comprehensive estate plan. And the reason being is, with a comprehensive estate plan, you're basically prepaying to save your loved one's money. Because with estate planning, so it's best to think of everything that you own in two categories: probate assets and non-probate assets. Probate is the court that handles estates. Probate asset is anything that does not automatically pass by operation of contract or law. A will is essentially a document that is used for the probate court to give them direction. So if you have a will, you have probate. Now, most people do not want to do this by themselves because it's a very time-consuming process, a lot of forms, a lot of hearings, things like that. So most people will hire a probate attorney. On the very low end, I think the lowest I've ever seen, you're going to spend $1,500 for a retainer, and that's just to have the attorney. A lot of times you're going to end up spending more than that. Then you have filing fees with the court. The court charges a percentage of the value of the estate. And then all of that can be dragged out by contests. If anybody wants to contest the validity of your will, contest, whether or not a certain beneficiary or a certain thing was intended to go to a certain beneficiary, it can get very expensive. And unfortunately, I have seen that. I've seen infighting bleed a family's estate. So instead of everybody getting something, no one got anything, because at the end of the day, attorney's fees and taxes and court fees ate all of it up. What I recommend for anyone who has assets, especially if you have a home, or any real property, is a trust. So a trust is essentially a contract. The way I explain it to people is it's good to think about it as its own business. Okay. So anything that you put in that trust belongs to it, not to you anymore. Now, as, like say, if I was doing an estate plan for you, you and your wife would be the initial trustees, which basically means you are in control of those assets. You're also the sole beneficiaries of that trust. So you can do whatever you want. But the second that you pass, all of those assets are subject to the provisions of that trust. But because everything is owned by this legal entity, none of it has to be probated. So rather than spending months or sometimes years, going over this stuff, getting court approval to do certain things, you just, your successor trustee by operational law has the ability to move money from your bank accounts, pay your debts, sell your house, transfer, the deed, whatever the case may be, without, this lengthy process. The other nice thing about a comprehensive estate plan is it's going to include, tax planning. So depending on if you have businesses, if you have stocks, or if you have any assets, they're going to put you into an estate tax bracket, there are different planning strategies that you can use to avoid that for your family. And then for my money, probably the most important thing in a comprehensive estate plan for your personal peace of mind is that it comes with a durable power of attorney and a healthcare power of attorney. Now, these documents basically authorize a person of your choosing to make a durable power of attorney to make financial decisions on your behalf, pay your bills, you access your bank accounts, carry on your affairs. And then healthcare power of attorney gives them the ability to act as what we call a patient advocate on your behalf. So if you're no longer able to make medical decisions, someone can make those decisions for you to the extent allowable by law. And the reason I say that is because some states and a lot of people think about what's called a living will. And some states recognize what we call advance directives, which is basically, this is what I want, this is what I don't want, and you have to honor my autonomy. Michigan does allow for the participation, but they also leave the final decision up to your doctors. So basically, to the extent that is allowable, you can, tell people what you do want, what you don't want in the event of your incapacity, if you're comatose, if you're unresponsive for X amount of time, things like that. And that allows that person to participate as if you were able to make those decisions yourself. And then the last thing there is what we call a pour over will, which, in a comprehensive estate plan would deal with that conservatorship, guardianship that we talked about earlier. But then also what it does is it acts as a catch-all. So let's say after you execute your trust, you buy another house, you buy an investment property, you start a business, and you never take the steps to direct that into your trust. A pour over will essentially says anything that I own at the time of my death that's not in my trust goes to my trust. So then you're dealing with a much smaller, more manageable probate estate, and the courts will kind of expedite that process because you're just pointing everything in one direction.
That makes sense. What is that process? Oh, so it's I have a home, a rental home. I've got couple cars. How long does that process take to say, Sean, I want an estate plan. I want to put this into a trust from start to beginning. Average, is that take years? Does it take months? What does that look like as far as actually implementing? I know maybe that's not hard to say because everyone's different, but in general.
And it is, but yeah, it's mainly, for the average family, of course, dictated by your ability to sit down and fill out the necessary documents. It takes about 2 weeks. So, I have an initial consultation. I have clients fill out paperwork that gives me an idea of where they're at financially so that I can make some recommendations. Then initial consultation is about an hour, gives me an idea of what their goals are and gives me an opportunity to educate them as to what kind of decisions they can make and need to make. And then from there, it takes about a week to 2 weeks to draft those documents, depending on the nature of what they're looking for. A lot of people don't realize the flexibility in these documents. You can put whatever conditions you want, that are allowable by law, time constraints, things like that. And so, depending on your unique situation, that can change things too. But the average family can have an estate plan done in about a month. You got the initial consultation, about 2 weeks for drafting. I will send out drafts. Once that's read and reviewed, any changes that need to be made and then we schedule a signing. And once those documents are executed, that's it. Unless you have any major changes that require, updates or amendments.
With the, after we sign, is there other steps with actually, how do I move the house that I own or the mortgage that I own into do I have to call my mortgage company and say, now this is owned by my trust? How does that part, that's something that's confused me as far as how do I get the assets that I already own into something that's new? How does that work?
So, and again, depending on the exact situation, it changes. But for instance, for most people, if you are talking about personal property, that is just basically a part of that signing. So because there is no account or, legal documentation for what you own in your house, that just as a matter of law can go right into your trust at the time of signing. As far as you mentioned cars, we actually, because of the no-fault laws, do not recommend moving your vehicles into trust for two reasons. One, there's a very simple and straightforward process through the Secretary of State where, your beneficiaries can move that. Now, you can outline your wishes as to, if you want somebody specific to have a car or something like that. But the second thing is that if you're using those automobiles and they're involved in an accident and they're owned by trust, now a person who's suing can go after the assets of that trust, which are otherwise protected for the most part from those types of challenges. So then when it comes to real property, a lot of people will just transfer a home to a trust by deed, just deed it to the trust, which actually Congress passed a law that makes that completely allowable without letting your mortgage company know. Nothing changes because ownership is not really changing hands. But what I do, because Michigan is unique in that it's one of 5 states that allows what we call ladybird deeds. A ladybird deed basically deeds your house from you to you for life. And you have the full power to convey it. You can give it away, sell it, whatever you want. But if you still own that real estate at the time you pass, it automatically transfers to the trust.
Gotcha.
And then, the deed and then with your bank accounts is the process of what we call funding. So when I draft a trust, I draft a ladybird deed for any real property. That gets recorded at the county level, and that funds what we call into the trust. And then with your bank accounts, all you actually have to do is, or your qualified plans, that's different. We'll talk about that. But with your bank accounts, all you do is go to the bank with your certificate of trust, which also comes with those documents, and you say, I want this to be the primary beneficiary of my account. And then that way, on your death, automatically the trust owns that account. And whoever the successor trustee is will have the documentation to show that they are, the legal person entitled to take hold of those funds.
Awesome. I got a question. This is maybe a personal question. What do you think the best way is to bring your family together and let them know? I have, Brett and Emily, I want you to raise our kids, but I also have Allison and Garrett and Ashley and Jimmy as my brothers and sisters. What have you seen to be the most effective way to actually have that conversation with your family of this is our wishes, this is what we want? You want to have a conversation of who's going to take your kids, but do I need to say, hey, I want you to have my guitar and actually say it out loud so that when they see it in the will or they see it, that it's known? What do you think is the best way to actually go and have those conversations? Or maybe even with my parents. Hey, mom and dad, you guys are in your 70s. I hope you live to be 100, but we know at some point you go away. How do we have those conversations? What's the best way to do that?
And that's the toughest thing that we deal with families, and there is no one size fits all. I mean, I always, recommend, leading honestly and not saying anything that you absolutely don't have to. So for instance, when it came time for me to ask my family members, would they be guardian of my daughter if something happened to me, I just kind of sat down and said, hey, this is what I'm thinking. And, luckily, I have a situation where my sister's about 14 years older than me. My wife's sister is 3 years younger than her. So we knew that those would be the people who would, not only step up, but would want to step up. And so the nice thing that I was able to do there is say, hey, if I died tomorrow, Stephanie, my sister, would you take my daughter? But then also I, was able to say, now I'm sure that you don't want to have the responsibility of raising a child, all that time. So if I were to die in, say, 10 years, then my wife's sister would be, the guardian. And so that kind of, made that a little easier. When you talk about personal property, yeah, I mean, when you have something like a guitar or something that has a lot of personal meaning or real value, it's best to be honest with everyone and to be, kind of public about it, and then have what we call a personal property memorandum. So typically you will split, you'll bring all of your personal property into the trust, And then you'll say, 90% of trusts say, well, my children are going to split this all equally. But that, to your point, can lead to a lot of infighting. Well, I loved dad's guitar. Dad taught me to play guitar, whatever. So having that written down, I want whoever to have that, helps with a lot of that. But then just being honest, so-and-so's getting it because he's the eldest. So-and-so's getting it because he wanted to be a musician, whatever the case may be. Yeah, he's my favorite. And now that I'm dead, I don't, feel bad about you reading that. No, but the main thing that we tell people is, especially in the documentation, your wishes, but not your reasoning, because there's just a hundred ways to contest. Well, that was true then, but it wasn't true later, or whatever the case may be. But yeah, it's unfortunately, it's the toughest part about this. And it's the toughest part about getting families to do this work, right? Because nobody wants to think about, the unavoidable. But also I think that, we all kind of hold on to our childhood sense of immortality for a lot longer than we, let on.
No, I agree. I think in my world, I have a very close touch with the mortality of life, like seeing people pass away. But I also understand that I probably have family members that don't have that and don't want to talk about it. Like, well, what are we going to do when so-and-so dies? I could say it like that because I understand it's going to happen.
Right.
But I've seen people, I don't want to talk about it. Well, it's going to happen. It's not because you talked about it. All parents are going to pass away. It is going to happen. We are going to, hopefully it all happens in order that I don't want to bury my kids. I don't want, I want my kids, like that should happen, but I think we have to talk about it. And I think having a plan gives you a little bit of peace that I've done I've protected my family. And I think as a man, we should be doing that. And this, I truly think, is a protection. And I have failed. I don't have a will. I have had conversations, but I don't. And I think this is definitely inspiring to maybe that it's not as big. Like I could do it today to start. I could write it on a piece of paper. Yeah, that is encouraging that's a thing. What else? Is there something that I don't know to ask? What's the question that I don't know to ask about estate planning that you haven't had a chance to tell me about that you think is important?
Well, as I said before, I think the number one thing is, if you have children, you need an estate plan. You may, change it later. You may add to it. That is the thing that I think most people don't realize is that when you don't have an estate plan in place, you are giving your loved ones an additional burden while they're already dealing with the difficulty of your passing. Because, I as a for instance, when my grandfather passed, because I deal with this type of thing and am used to having tough conversations, when I went to the funeral home, I could tell that, my father and my uncle were really upset and didn't necessarily, I don't want to say they didn't have the capacity to make the decisions, but I don't think they wanted to. It wasn't, on their mind. And those are the unavoidables. You have to pick out a casket. You have to pick the, flower arrangements, things like that. But what you don't have to leave your loved ones with is this lengthy court process and these lingering questions about, how do we go through all this stuff and what do we do? And I think that's the number one thing that people don't really think about until they have to deal with the probate process themselves.
Right. Do you see people actually plan out their funerals? I don't know, like, hey, I'd want to take away some of this is the casket, I picked it out. This is have you seen anybody? Is that a thing?
So it is a thing. It is less common. So we do include pages for things like that in the estate plan. Wishes. Maybe you want to have a memorial service at a certain church, or you want to have a certain flower or whatever present. But I think that most people, the one thing that they do is get their cemetery plots, which is probably the most that most people do.
Yeah. My dad, he told me, I wouldn't be cremated. He's like, besides that, I'm going to be gone. I don't care what you do. And I told him, no, Dad, you know what I'm going to do? when you're cremated, I'm going to take some of your ashes and I'm going to put it in a shotgun shell and I'm going to kill a turkey with it. He's like, that is so cool. He was so excited. I've told people that. They're like, I really like that. I'm like, yeah, it's going to be great. I'm going to take him hunting with me. Maybe I'll get 2 or 3 in case I miss. And I'm going to kill a turkey with him because that was one of our favorite things to do. So he knows he's got at least one plan. So besides that, that's the only planning we've done. But yeah, I'm going to sit down. I think you've inspired me and hopefully other guys to at least make a will, and if not, find an attorney. Can you practice this anywhere, or are you just in the state of Michigan?
So in the state of Michigan, some states do not require you to be an attorney to execute an estate plan, but many do require you to be an attorney to execute deeds and things like that. So it's kind of one of those catch-22 situations where it's like, yes, I could do you an estate plan, but then you'd have to pay another attorney to do your deed and things like that. So primarily, I only look to practice in Michigan.
Right. And if you don't feel comfortable giving me numbers, but in general, if I wanted a full estate plan to put my house and everything I have into a trust, are we talking $10,000, $500? Where does that usually, range in just like a normal family with a couple kids, a house, a couple cars? Where does that normally, what's a range the guys are looking at?
So the average estate plan for a family is going to run you in between, $1,500 and $2,000. But, as I said, that's going to include a trust, a pour over will, powers of attorney and healthcare power of attorney for you and your spouse, as well as HIPAA, which is, just gives your loved ones access to that, as well as consultations, the drafting and the signing, which requires, so you need 2 witnesses, as well as typically your attorney will act as your notary public for a valid will. And then, although it's not strictly the law, we just have gotten into the habit of saying the best practice is to do that on all of your estate planning documents. My services typically are $1,800 for friends and family, and for your listeners, I'm doing $1,400 for a family estate plan. And then for an individual, it's typically between $1,000 and $1,500 for the one set of documents.
Yeah, that is, you go get a staple taken out of your foot at the emergency room, they're going to charge you $1,500. I think that's...
Oh, absolutely.
That is a very, that's reasonable. Like, I'm sure there's some people who can't do that. Like, if they're scraping things together to make ends meet, but to protect your family, like if you would go out and spend $1,000 on a gun to protect your family, you should go spend $1,800 on an estate plan so that your kids go to the house you want them to go to and have the money. I think that is very doable, very reasonable. I think it's a very noble thing that you are doing. That is, protecting people's assets and their wishes, Sean, I think is noble. It's a really good thing. And I'm really thankful that we could have this conversation. I think this information really, it could change legacy, right? It could put people where they need to be. What is the best way for people to get a hold of you if this is something they want to go forward with?
Yep. So I have a website. It's slparent, PARENT, There you can, contact me. My phone number, emails on the website as well. I actually get a link up, but I have an automated scheduler that I'm getting up on there as well, so that you can just go on and set a consultation with me. When I get that information, I send out questionnaires, and that gives you the ability to kind of sit down. And the nice thing about the questionnaire is before you even have that first meeting, you kind of get an idea of some of the considerations, some of the things that you might not immediately think about. Like, so as a for instance, and I meant to bring this up earlier, just as one of the more important points about having a trust, especially if you have minor children, is if you don't have a trust, when your kids turn 18, if you die before they reach that age, and you don't have anything else set up, by operation of law, they get everything. And that, to me, is almost as dangerous as leaving them nothing. Because an 18-year-old with $250,000 or $1 million or whatever it is, once that you liquidate everything, is 9 times out of 10 going to be wasted. But with a trust, you can say, okay, I want this money to provide for them, their, health, education, maintenance, and then I want to give them percentages throughout stages of their life. So those type of things come up in the questionnaire, and it gives you the ability to, start to think about how you would want your loved ones to be taken care of if you weren't able to do it yourself.
Yeah, that's awesome. I actually heard it was one of the guys on Shark Tank. I forget which one. He was talking about leaving money to his kids, and he's like, I want to give them enough money that they can do anything they want in the world, but not so much money that they can do nothing. And I think that's probably where our trust comes in. Like, I want you to have a good life and be able to do things, but if I give you so much that you can do nothing for a while, I have hurt you. So I think that is huge. Well, Sean, I really appreciate that. This will be the end of the podcast. So if you like this, you're listening to it, put what you learned into action. Contact Sean, get a will, contact an attorney, get out there and get your estate plan. Remember, if you're going to earn the title, you have to put something in action. So do that. Thank you so much. Now we'll talk to you later.